Hello, my name is Nick Cohenmeyer, and today I'll be talking about Assembly Bill 3088, which is also known as the COVID-19 Tenant Relief Act of 2020. I will be referring to AB-3088 as the Tenant, Homeowner, and Small Landlord Relief and Stabilization Act of 2020. I will also be referring to it as its abbreviation, CTRA, which stands for COVID-19 Tenant Relief Act of 2020. The CTRA, again AB-3088 as I will be referring to in this presentation, was enacted via AB-3088 on August 31st, 2020 and took effect immediately prior to the September 1st, 2020 expiration of the California Judicial Council's Rule 1, which had effectively banned most unlawful detainers in California that weren't otherwise necessary to protect public health and safety. The CTRA is also known as the Tenant, Homeowner, and Small Landlord Relief and Stabilization Act of 2020. Again, I will be referring to it as the CTRA. One of the most important takeaways of the new CTRA is that landlords are essentially barred from until February 1st, 2021 from evicting a tenant who complies with a declaration and partial payment requirements for tenants who are or were unable to pay the full rent between March 1st, 2020 and January 31st, 2021. The protections under the CTRA apply to all residential, mobile home, single-family home, and accessory dwelling units, ADU, tenants in California, regardless of the immigration status of the tenant and regardless of whether a formal lease was signed between the tenant and the landlord. For the purposes of this presentation, again, I will be using the terms COVID-19 Tenant Relief Act of 2020, CTRA, AB 3088, and its full title, the Tenant, Homeowner, and Small Landlord Relief and Stabilization Act of 2020. Now, in early September, the Centers for Disease Control and Prevention, CDC, announced its own freeze of evictions for certain residential tenants. So how does the CDC eviction moratorium interrelate with the CTRA? In general, California's CTRA will provide broader protection to tenants who have been adversely affected by COVID-19 than the CDC ban. For tenants who have not been financially affected by COVID-19, these otherwise unprotected tenants might have some protections under the CDC eviction ban. This presentation will be focusing on California's CTRA, but if you want more information about the CDC eviction ban, you can let me know in the comments and I might do another presentation specifically on the CDC eviction freeze. While both the CTRA and CDC eviction freeze offer broad protections to tenants, I have not seen any protections to tenants against at-fault evictions, such as for tenants who cause a nuisance or breach a material term of the lease, or who were already in arrears before the pandemic began, which, for the purposes of the CTRA, would be March 1st, 2020. Now, in addition to the CDC eviction freeze and CTRA protections, there is also the 2019 Assembly Bill 1482, known as the California Tenant Protection Act from last year, and that's at play here in areas such as at-fault versus no-fault just cause eviction. Lastly, AB 3088 had to be a compromise between the needs of tenants who are unable to pay rent that is and will be due to financial hardships arising from a loss of income or increased expenses associated with COVID-19, as well as the needs of landlords who are still obligated to satisfy their expenses such as repairs, insurance, etc. on the rental property, despite receiving partial or no rental income from some tenants during this crisis. Keep in mind that there had been a push by some tenants' rights group to outright cancel some of the back rent owed to landlords during this period. So while some landlords will complain that AB 3088 doesn't go far enough to protect their interests, they should at least be relieved that all of the rent that is owed to landlords by tenants will still be owed to landlords, even though AB 3088 adds some requirements and delays to the ability of landlords to collect the full amount of rent that is due. Now, there are two key timeframes associated with AB 3088. I will discuss the protected time period first, followed by the transition time period. What is the protected time period? The first period I will refer to began March 1st, 2020, when the severity of this pandemic was first being discussed and discovered in California. It ended August 31st, 2020, which was right before AB-3088 took effect. Under AB-3088, this period, again from March 1st, 2020 to August 31st, 2020, shall be referred to as the protected time period. If a tenant defaulted on the rent at any time during the protected time period, then the landlord will be barred from evicting that tenant so long as the tenant completes and returns the blank declaration of COVID-19 related financial distress that the landlord will hand to the tenant in advance for the tenant to fill out as an official way for a tenant to declare that the tenant's finances were negatively affected by COVID-19. If a tenant is deemed a high-income tenant, then the high-income tenant may also be required to provide documentation of her COVID-19 financial hardship. Let me restate this so it's clear for landlords. A landlord is now permitted to send a 15-day, and that's 15 court day, notice to pay rent or quit for rent that a tenant didn't pay in part or in full during the March 1st to August 31st protected time period. If the landlord is going to send such a notice to her tenant, then the landlord must also include a blank declaration of COVID-19 financial distress for the financially affected tenant to complete and sign under penalty of perjury. Once the landlord sends the AB-3088 compliant 15-day notice and blank declaration of COVID-19 related financial distress to the tenant to pay for missed rent during the protected time period, the tenant will have 15 court days to complete, sign, and return the completed declaration of COVID-19 related financial distress to the landlord. So what if a tenant fails to return the declaration of COVID-19 related financial distress to the landlord within 15 days, or fails to provide an acceptable reason for non-payment of rent? In that case, landlords are permitted to bring an eviction suit against such an unprotected tenant, and that began October 5th, 2020. So, by the time you're watching this, landlords are now permitted to bring eviction suits against tenants who are not claiming any COVID-19 related financial hardship. Now I talk about the sample declaration and notice. And you can see on your screen we have an example of the COVID-19 declaration as well as an example of a 15-day notice. But keep in mind, a little trick here, that notice is only good during the transition time period, not the protected time period. They have different language, and it's important to understand the distinction, and I'll go through that in a moment. So if you have a tenant who is in arrears since March 1st, 2020, you will have to serve them with a notice to pay or quit. However, because of COVID-19 and the CTRA, you cannot simply give the tenant a normal 3-day notice to pay or quit. Instead, you must now provide the tenant who is behind in rent a new 15-day notice to pay or quit. So on the screen, you'll see an example of this 15-day notice to pay or quit, and that is for the transition time period. So we have different notices depending on the period because there's different requirements. And as you will see in a moment when I discuss the transition time period, tenants have to start paying 25% of the rent that is due if they're claiming COVID-19 financial hardship. That's not relevant or required during the protected time period. So the language is different on the notices. Now if I show you an example of the notice during the protected time period, it would look like this. And you will be able to identify it quickly by just looking at how it's identified in the header, that it's for non-payment of rent between March 1st, 2020 and August 31st, 2020. And what period is that? That's the protected time period. So there's more to know about these notices, and I will discuss them in a few moments, but keep in mind that the tenant has to sign and return the COVID-19 financial distress form, and that's due within 15 court days. So don't count calendar days, you have to count court days. So you can't count weekends and you can't count holidays that the courts are closed. Now I'm going to talk about the transition time period. The second period under the CTRA is between September 1st, 2020 and January 31st, 2021. 2021, okay? Not 2020. I will say it again. September 1st, 2020 and January 31st, 2021. And what is that? That's the transition time period. So, just as during the protected period, California landlords will be barred from evicting tenants during the transition time period if the tenant submits a written declaration to the landlord affirming the tenant's finances have been adversely affected by COVID-19, such as by loss of income and/or an increase in medical-related expenses, for example. Also, same as before, high-income earners may be obligated to submit documentation in addition to their written declaration to prove their COVID-19 related claim for rent relief. Here's where the key difference between the protected time period and transition time period, other than the dates, is. For tenants claiming COVID-19 related financial hardship during the transition time period and seeking protection from eviction for being unable to pay the full amount of rent due during this period, the tenant will now be obligated to pay 25% of the rental payments that accrue during the transition time period. Again, the tenant only needs to pay 25% of the outstanding rent that accrues during the transition time period, not during the protected period. The 25% payment must be made to the landlord no later than January 31st, 2021. So because tenants are entitled to wait until January 31st, 2021 to provide 25% of all back rent that has accrued since September 1st, 2020, landlords cannot begin the eviction process until about a day later, February 1st, 2021 at the earliest. The statutory language that must be included must be in 12-point font, and I'm talking about the 15-day notice, which demands rental payments that arose between September 1st, 2020 and January 31st, 2021, again known as the transition time period. And as I showed you in the previous screen, the actual form looks like this. So it's a 15-day notice, so make sure you tell them apart. All right, one of these is for the transition time period, the other is for the protected time period. Don't use the form for one period if you are sending a notice for a different period. Now you might have a tenant who is in arrears for both periods. You would have to serve them the notice in the protected time period that has already passed, but the transition time period that we're now in, make sure you're not serving them with a notice that pertains to the protected time period. It should be obvious, but it's better to hear it and be extra safe than not hear it and just assume that it won't be an issue. Okay, so for tenants, well, let me skip back a moment here. So you can get the notices like this on lawhelpcalifornia.org. It's law, LAWHELPCA.org. lawhelpca.org. So for tenants who have not sufficiently demonstrated evidence of COVID-19 related financial hardship, the earliest evictions can resume for these tenants is October 5th, 2020. This suggests that October 5th, 2020 would be the earliest a landlord could serve a tenant with a notice of eviction for tenants who have not shown or tried to claim evidence of COVID-19 related financial hardship. Of course, the landlord would still need to go through the unlawful detainer proceeding and get a favorable judgment before a tenant can be forcibly removed. Now for any resident, and I'm using the term resident and tenant interchangeably here, who otherwise complies with the declaration and documentation, if applicable, if they're a high income earner, but does not make the 25% payment by January 31st, 2021, then the landlord can file an unlawful detainer action beginning February 1st, 2021. For tenants who fail to make payments during the transition time period, again September 1st, 2020 to January 31st, 2021, the landlord cannot and can never bring an unlawful detainer suit against the tenant, but provided the tenant does all of the following: submits the COVID-19 financial hardship declaration and pays 25% of the rental payments no later than January 31st, 2021, which were missed during the period the tenants experienced COVID-19 financial distress, and again, which was during that transition time period. So we have a financial hardship declaration. We also have a cover sheet that the tenant should submit. And this is an example of COVID-19 related financial distress. And you can see, if it shows up clear enough, that there are 6 potential reasons for why the tenant is currently unable to pay rent or other financial obligations. They would have to claim that they're being affected by one or more of those reasons, as well as attest that any public assistance, pandemic unemployment assistance, disability insurance, paid family leave, etc. that they've received since the start of the pandemic does not fully make up for the loss of income and increased expenses. This has to be signed by the tenant under penalty of perjury. So even though this presentation is designed more for landlords, I know tenants will be watching this. If you're a tenant and you're not actually affected by COVID-19, you just want to pay less rent in the short term, thinking that you'll just make it up in the future, no problem, that is not without consequence. Even though you are not affected, you cannot claim COVID-19 related relief under the CTRA, because this has to be done under penalty of perjury. Don't try to do yourself a quick little favor. You're going to get yourself into a big problem later for doing that. Keep in mind that this has to be a balance. CTRA is trying to help out not just the landlords, but the tenants too. So both sides can't get everything they want, but they have to respect the rules that are in place, not try to game the system. And as the landlords will see, the penalties for harassment or discrimination for tenants that are not paying are so severe that you are better off just keeping your mouth shut if you have a tenant who isn't paying, because you could face over $2,000 in fines, per infraction. I'll talk about that towards the end of this presentation. So the 25% payment can be made by the tenant all at once, anytime before January 31st, 2021, or in installments. But the total amount equal to 25% of the missed payments that arose between September 1st, 2020 and January 31st, 2021 has to be paid no later than January 31st, 2021. So although the landlord can never evict the tenant for failing to make the rest of the 75% amount of rent that accrued during the transition time period, provided the tenant complied with the requirements above, the landlord can still go after the tenant to collect the 75% remaining in small claims court. And I will cover this in an upcoming slide entitled Collecting Rent and Other Charges. Now that you see the distinctions between the protected time period and the transition time periods, keep in mind that a significant commonality that they share is that financially affected tenants who comply with the rules for each period can never be evicted for missing rent during these periods, and no matter how long the tenant remains as tenants afterwards. Of course, the tenants will still owe this back rent and should try to work out a compromise payment plan with the landlord, but the landlord is not obligated to accept a compromise in the amount the landlord is entitled to recover in small claims. So let me say that again so it's clear. The landlord is not obligated to accept a compromise from the amount that the tenant lawfully owes the landlord. If the landlord wants to accept a compromise payment because maybe they'll get 60% of what is owed all at once versus wait for the rest of it that might never come, that's totally up to the landlord to work out with the tenant. If you do have an arrangement like that, make sure it's in writing, make sure it's signed by both parties, make sure you scan it and save it in a place where you can easily locate it, and you will have a strong leg to stand on if the landlord eventually comes back and says, you owe me the rest of this money someday. So you're protecting yourself by doing that. Now I'm going to discuss resumptions of evictions. So when can evictions resume in California under AB-3088? Beginning September 2nd, 2020, evictions for cases other than non-payment of rent or other charges, such as for tenants causing a nuisance, health and safety threat, those were permitted to begin. October 5th, 2020, that added cases for non-payment and other rental-related charges unless the tenant provided the landlord with a proper declaration of COVID-19 related financial distress. And if the tenant was determined to be a high-income tenant, then that documentation would also be required for high-income tenants. So again, October 5th, 2020, that resumed evictions for tenants who are not affected by COVID-19 in terms of financial effect. February 1st, 2021. This will be the currently scheduled date for all unlawful detainer cases to resume in California, notwithstanding any alterations to the provisions of AB-3088 by the California legislature before then. And then March 1st, 2021, this is when landlords can begin bringing suits against tenants in small claims court for unpaid rent, though technically a landlord could bring a civil suit against a tenant for unpaid rent at any time. Now I'm going to talk about the requirements for a resident's declaration of COVID-19 related financial distress arising during their protected or transition time periods. This will be the hardship declaration. Now, we talked about the hardship declaration. If the tenant is submitting a hardship declaration, they should also submit the cover sheet. It's a UD 104 form, and that's different because the declaration is UD 104 alpha, and then the cover sheet is just UD 104. It's a judicial counsel form. You can search for that. You should be able to search just by the nomenclature UD 104, and then you can see what it says, cover sheet. So the protections from eviction for non-payment of rent due between March 1st, 2020 and January 31st, 2021 apply if the reason the resident didn't pay was because the resident had experienced COVID-19 related financial distress, which includes any of the following: reduction in income due to the COVID-19 pandemic, increased out-of-pocket expenses directly related to performing essential work during the COVID-19 pandemic, increased expenses directly related to the health impact of the COVID-19 pandemic, child care responsibilities or responsibilities to care for an elderly, disabled, or sick family member directly related to the COVID-19 pandemic that limit a resident's ability to earn income, increased costs for child care or attending to an elderly, disabled, or sick family member directly related to the COVID-19 pandemic, other circumstances related to the COVID-19 pandemic that have reduced a resident's income or increased a resident's expenses. So some of the methods for how a resident can return a declaration of COVID-19 financial distress and documentation: in person, provided the landlord provides an address in the notice for which the declaration can be delivered; by electronic transmission, if the landlord indicates an email address in the notice to which the declaration may be delivered; through USPS mail to the address indicated by the landlord in the notice; through any of the same methods that the resident can use to deliver the payment pursuant to the notice, where delivery of the declaration by that method is possible. Only one declaration per household or tenancy is required, and you can see an example of that hardship declaration on the previous slide, the protected time period. High-income tenants. Now I'm going to discuss documentation requirements for high-income tenants. Another significant new change with AB-3088 is the obligation to provide substantiating documentation of reduced income or increased expenses due to COVID-19 for high-income tenants who are claiming a COVID-19 related inability to pay the full rent due. Here are the steps on how to determine whether a tenant falls under the high-income category. Looking in the Department of Housing and Community Development in the official state income limits for 2020, you will need to check the specific county for which the rental property is located. Next, you will need to determine household size. Household size is based on the total number of lawful occupants of the residential unit, and this does include minor children. If the tenant's annual household income is at least 130% of the median income as published in the HCD, again, Housing and Community Development, then the tenant can be considered high income. And again, HCD, Housing and Community Development, which is in the official state income limits, and you're going to look for 2020. And the link to the HCD official state income limits for 2020 I put on the bottom of the screen, and that link is hcd.ca.gov/grants. You'll see it at the bottom of your screen. If anybody has any trouble accessing it, leave a comment. I'll include an updated link if it has changed. There is a minimum median income lower threshold of $100,000, meaning that if a household, regardless of its household size, earns below $100,000, then that household will not be considered a high income household, regardless of what the median income is in their county. So even if earning $95,000 would place a household within 130% of the median income for the county, that household cannot be considered high income because the household earns less than $100,000. Now here's an example of where a household would be considered high income. According to the HCD state income limits of 2020, the median household income in Santa Cruz is $110,000. So 130% of that would be $143,000. So in order for a household in Santa Cruz to be considered high income, the household would need to have an annual household income of $143,000 or more. A landlord cannot serve a 15-day notice claiming that the tenant is a high-income tenant if the landlord does not have proof of the tenant's income in the landlord's possession. But since a landlord can neither request nor can a tenant be required to provide proof of income for the purposes of determining a tenant's high-income status under AB-3088, I will explain in the next slide how a landlord can lawfully make such an income determination. For high-income tenants who properly submitted their declaration of COVID-19 related financial hardship but neglected to submit their documentation, the landlord can file an unlawful detainer action against these tenants beginning October 5th, 2020. Requesting income documentation. So, if a landlord first has proof of income showing that the resident is a high-income tenant, then the landlord may, second, require the tenant to provide documentation of COVID-19 financial distress, provided the landlord includes the following language in the landlord's 15-day notice. Again, must be in 12-point font. And you see the notice on your screen. Proof of income on file with your landlord indicates that your household makes at least 130% of the median income for the county where the rental property is located. So you can see the rest of the form. If you want to look it up and get a form like this, you can go to lawhelpca.org. It's a link that I included earlier in the presentation. There's other places to get this, but just look for Code of Civil Procedure section 1179.02.5 subsection delta. It's on the screen here. So, after the landlord, who has unsolicited knowledge of the tenant's high income status and serves the tenant with the 15-day notice, fails to receive the tenant's financial hardship documentation or tenant's hardship declaration, then the landlord can file an unlawful detainer action starting already, October 5th, 2020. Now, to make sure this is clear, you as a landlord cannot demand that the resident provide financial hardship documentation before you've determined whether the tenant has suffered income loss or before you've determined whether the tenant is a high income earner. Just as you cannot demand that the tenant provide income verification at the earlier stage. In other words, you have to have your own independent income verification, and that can be based on the initial tenant screening process, but you can't demand that the resident provide either income verification for the determination of whether they're high income, or provide financial hardship documentation when you're determining whether the tenant has actually suffered income loss. Because that decision, whether to disclose such financial information, is always a decision that only the tenant can make, and the tenant cannot be compelled to make. So keep in mind that during the protected period, again, what is it? March 1st to August 31st, 2020, a landlord cannot evict a tenant for missed payments, provided the tenant submitted the COVID-19 financial hardship declaration and submitted the financial hardship documentation if the tenant qualified as a high earner, which is what we're talking about. So if the tenant doesn't comply with these requirements, only then can the landlord bring an unlawful detainer suit against the tenant, so long as it's not done earlier than October 5th, 2020. However, the landlord can still go after the tenant for the unpaid rent in small claims court. Required documentation by landlords. While tenants financially affected by COVID-19 will be required to provide a declaration and possibly documentation attesting to their financial inability to pay the full rental amount due, a landlord will also need to submit documentation. So for landlords filing unlawful detainers while AB-3088 is in effect, the landlord needs to file a supplemental cover sheet to assist the courts in determining which phase of California's unlawful detainer resumption the landlord is filing pursuant to. The landlord's cover sheet must disclose whether the landlord is seeking to reclaim possession of the property due in any way to the tenant's financial default or due to a no-fault reason. So, cover sheet for landlords. This is an example from Solano County Court. So if you're filing in San Diego County, don't use this form. This is just an example, but it's an unlawful detainer supplemental cover sheet. And some of the things it asks are whether it's for residential or commercial property. It asks why you are seeking to evict the tenant, and it very clearly asks it does include the tenant's failure to pay rent or it does not include the tenant's failure to pay rent. And if the reason does include failure to pay rent, then all tenants have been served with COVID-19 rental debt information in accordance with Civil Code 1179.03, and the tenant has or has not submitted a declaration of COVID-19 related financial distress. So, first, the landlord serves everybody who's in arrears, who's behind on rent, with this notice. And I don't see any problem with just serving it to every tenant, whether they're in arrears or not. I could be wrong on that, but this has to at least go to every tenant who was in arrears during the protected time period or transition time period. It gives them the rights that they have, and it talks about the different time periods, so that gets served to them first. And then it's up to the tenant to submit a declaration of COVID-19 related financial distress. And if they do that, then they should also file the cover sheet. All right, so the defendant, meeting the tenant, would reply with that. And if you know that your tenant was high income earner at the time they commenced that lease, you need to give them the additional information about high income earners, and then they would have to submit. All right, that's the notice for high income earners, and then the high income earner would have to submit, in addition to the declaration, the documentation, if the high income earner is attempting to show that they have suffered financial harm. So all tenants who have suffered financial harm need to submit a declaration. Only high income tenants who have suffered financial harm need to submit the documentation. If a high income earner is not claiming any COVID-19 related financial hardship, they don't need to submit either. They just need to pay the full amount of rent that's due. Now I'm going to talk about landlords' required documentation. So, how to request income verification from a resident? As you probably guessed based on the myriad protections already provided to California tenants, if you would have guessed that California would prohibit a landlord from demanding income verification from the resident for purposes of determining whether the resident is a high income tenant, you have guessed correctly. And you've also seen the previous slide as I talked about that. So I just want to make sure this is totally clear. A landlord can neither request nor can a tenant be required to provide proof of income for the purposes of determining the high income status for a tenant under AB-3088. And no, this does not mean that a landlord can go behind the tenant's back and procure such income verification about the tenant from the tenant's employer or any other organization or agency. It has to come from the tenant. So in the event a landlord obtains confidential financial information about his tenant, this information that was obtained without permission of the tenant will be barred from the landlord's use. So, how will the landlords obtain this privileged financial information without running afoul of AB 3088? One way a landlord can lawfully determine a tenant's income status is by using the proof of income submitted by the tenant during the screening process. Now, I am going to talk about some of the valid methods for determining proof of income under AB 3088. And this is generally what the tenant might have submitted at the time they commenced the lease or month-to-month rental. Tax returns, W-2s, written statements from a resident's employer specifying this resident's income. And I'm using the term resident and tenant interchangeably through this presentation. Pay stubs, documentation showing regular distributions from a trust, annuity, 401k pension, or other financial instrument. Documentation of court-ordered payments, such as spousal support or child support. Documentation from a government agency showing receipt of public assistance benefits, such as Social Security, unemployment insurance, disability insurance, or paid family leave. A written statement by the resident which states the resident's income, such as a rental application. So you don't get to play by different sets of rules as a tenant. If you tried to show that you're a high-income earner because you were trying to impress the landlord so you would get the rental or lease that you wanted, you don't get to suddenly claim poverty and say, I can't pay, just take my word for it. As a high-income earner, because you were able to maybe get that rental ahead of somebody else who doesn't make as much money, you're now in an elevated position, and the responsibilities that come with that, the burdens, if you will, are that you now have to substantiate a substantial loss of income because you're considered a high income earner. I hope that makes sense. In the next slide, I will show an example of the landlord's required COVID-19 supplemental cover sheet for unlawful detainers that complies with Civil Code 1179.03. So, as I spoke about a few minutes ago, or if you're just tuning in now, for the supplemental cover sheet, that would be for the landlord to submit. Here's how it would look. This is the Solano County example, so don't use this if you're not in Solano County. That's just one example of how it would look. And a landlord needs to submit a supplemental cover sheet each time the landlord initiates a new unlawful detainer case during this pandemic. And some of the important details that the cover sheet has to include are whether the case seeks possession of commercial or residential property, whether the reason for the eviction is due to the tenant's failure to pay rent, and whether the tenant has submitted a declaration of COVID-19 related financial distress. Now I'm going to talk about just cause. Under last year's AB 1482, and which extended beyond its original scope, is the just cause provision, which makes it illegal for a landlord to fail to provide a tenant a specific reason for an eviction in an eviction notice. So not only must the specific reason be stated in the notice, but it also must be one of the valid at-fault or no-fault reasons stated in the law. The just cause protections of AB 1482 now apply to nearly all tenancies until February 1st, 2021, with a few exceptions and exemptions. So if you, a landlord, are planning to evict your tenants prior to February 1st, 2021, you'll have to explain to the tenant you are evicting whether the eviction is for an at-fault or no-fault reason, unless your property is not covered under AB 1482 or AB 3088 due to an exemption. So here are some of the exemptions for which the protections of AB 1482 and AB 3088 categorically do not apply. Transient occupancy rentals, so hotels and motels. Corporate rentals for commercial tenants, such as an LLC that rents a location rather than a natural person. Commercial tenants, such as a person or entity that rents any property that is not a dwelling unit. And here are the exceptions for which the protections of AB 1482 and AB 3088 also categorically do not apply. Evictions for demolition or substantial renovation, which are now limited to circumstances where it's absolutely necessary for compliance with health and safety laws. There's also an exception for single-family home and condo owners who have a contract for sale with a buyer who intends to occupy the unit. And lastly, there's an exception for tenancies, which were already terminated before March 1st, 2020. The only property use exceptions to just cause protections are evictions due to demolition of the premises or the substantial rehabilitation of the property that is necessary to comply with health and safety laws. So keep in mind that while AB 3088 clearly applies to rent or any other financial obligation of a tenant under the tenancy, AB 3088 also applies to any other financial obligation of a tenant under the tenancy. In other words, the protections of AB 3088 may apply to essentially any expense associated with a tenancy, such as gas, water, internet, parking, cable, etc. So if you have a tenant that is creating a nuisance and is also not paying rent, you should send 2 separate notices so that the repair costs would not be considered rental payments, which would fall under the purview of AB 3088's protections for non-payment. Lastly, the limitations on evictions in AB 3088 apply to more properties than are normally covered by AB 1482. AB 3088 applies to all residents, even if the resident wasn't covered under AB 1482. However, the eviction protections under AB 3088 are scheduled to sunset on January 31st, 2021, unless extended by the California legislature. As you saw in the earlier slide, California courts began hearing, normally via virtual hearings, or for just causes. In other words, they started hearing cases for just causes other than non-payment of rent or other charges, and that started on September 2nd, 2020. Since October 5th, 2020, courts have broadened the scope to now include cases for non-payment of rent and other charges, unless the resident properly provided the landlord with a declaration of COVID-19 related financial distress and income documentation if the tenant is deemed a high-income earner. Now I'm going to talk about at-fault versus no-fault termination. Under AB 1482, again, last year's bill applies now, broadened under AB 3088, there must be a just cause identified and expressed as a basis for termination of a lease or rental agreement. Within just cause, there is a distinction between at-fault and no-fault termination of tenancies. The key distinction is whether the reason for the termination of the lease or rental agreement is due to any fault by the tenant. A no-fault determination is when the landlord terminates the tenancy not due to any fault of the tenant. And an at-fault termination, and I said determination before, you determine whether the tenant is at fault or not at fault, and then you terminate based on that. So an at-fault termination occurs where the tenant has committed some kind of nuisance, breach, or unauthorized use of the premises, and I will give examples of each next. The primary distinction of an at-fault versus a no-fault eviction is that landlords are largely barred from evicting COVID-19 financially affected tenants under no-fault evictions until January 1st, 2021, unless the eviction is required to comply with health and safety laws. Another distinction that is somewhat important is that under an at-fault termination, a landlord would not need to pay a relocation fee to the tenant, whereas a landlord might need to pay a relocation fee to the tenant under a no-fault termination. AB 3088 does not change these default presumptions, with one exception. AB 3088 allows a landlord to offset unpaid rental fees against the landlord's relocation assistance obligation under no-fault termination, where AB 1482 applies. Unless the unlawful detainer was filed and expired against the tenant prior to March 1st, 2020, or if the contracted sale for single-family home exceptions applies, a court will require either an at-fault or no-fault reason in order for a tenancy to be terminated. So, let me discuss at-fault terminations. Here are the statutorily recognized examples of at-fault reasons for terminating a tenancy. Nuisance, which would be maintaining, committing, or permitting a nuisance. Waste, committing waste, as defined in the lease or rental agreement. Termination of the lease, if the tenant had a written lease with termination dates on or after January 1st, 2020, and the tenant refused to sign a written extension of the lease with a similar duration and similar terms as the expired lease. Criminal activity by the resident, especially in common areas, also includes criminal activity or criminal threats, whether on or off the premises, if directed at any owner or agent of the property. Unauthorized sublease, assigning or subletting the tenant's unit without the owner's express permission. Unlawful purpose, using the premises for any unlawful purpose, such as drug manufacturing, drug dealing, prostitution, etc. Unauthorized denial of authorized entry. tenant's refusal to allow an owner or agent to enter the premises for a legitimate purpose as defined in the rental lease agreement. Employee's termination, failure of the employee to leave an employment-based tenancy following the employee's termination. Failure to return possession. If the owner has accepted a resident's written notice to terminate the lease and the resident fails to deliver possession to the owner, that would be a failure to return possession. Let me talk about default versus material breach. So normally a default is when a tenant fails to make payments that have come due. And keep in mind that if the tenant defaulted on rent that came due between March 1st, 2020 and January 31st, 2021, or defaulted on charges other than rent, there are limitations on a landlord's ability to evict, as I discussed earlier. Material breach. This would be a material breach in the material term of a lease or rental agreement by the tenant. And an example of this would be having an unauthorized pet or unauthorized subtenant. Changes in notice for material breach. So since AB-1482 was passed in California, a landlord wishing to evict a tenant for an incurable breach, let me say it again, incurable breach, must normally send the tenant a 3-day notice to cure or quit. However, since AB-3088 was passed, the landlord must also send the tenant a 15-day notice to perform covenants or quit. No-fault termination. Now I will discuss and give some examples of no-fault termination. So, intention to move in family or relatives. A landlord is permitted to force a tenant to move out if the landlord has a genuine intention to allow the landlord's spouse, domestic partner, children, grandchildren, parents, or grandparents to move into the tenant's unit. After July 1st, 2020, in order for this to be considered a no-fault reason, the tenant must either have consented in writing to the move-in of the landlord's family, or a specific provision of the lease has authorized this no-fault reason, and that provision of the lease, i.e. the whole lease really, needs to be signed by the tenant if there's any change into it, to show that the tenant understands and consents to the change in the lease. So again, if you're reading this or watching this now, it's after July 1st, 2020. So if you are trying to move in family or relatives and consider that a no-fault reason, which is one of the allowable reasons to terminate a tenancy, then those two requirements apply, one of the two. The tenant has to have consented, or you have to have had a specific provision of the lease that authorizes the landlord to terminate a lease due to the intention to move in family or relatives. Withdrawal of premises from the market. This is where a landlord decides to remove a residential property from the rental market, and this could be a no-fault reason for a landlord to terminate a tenancy. Habitability. If a landlord is complying with a habitability requirement that necessitates vacating the property, or a governmental agency order, or a local ordinance that necessitates vacating the property, this can be also considered a no-fault reason. Intent to demolish. It will be considered a no-fault termination where a landlord intends to demolish or substantially remodel a residential real property in order to maintain the unit's compliance with laws concerning the habitability of the rental unit. Now, exclusive to AB-3088, and this didn't apply in AB-1482, is the contracted sale exception. So, if a landlord is in the middle of selling a property at the time the eviction notice is filed, then the landlord can be exempt from the just cause requirements of AB-1482, provided the single-family home is not owned by a real estate investment trust, corporation, or limited liability company if at least one member is a corporation, and the landlord has complied with AB 1482's requirement to give the resident a written notice that their property is exempt from AB 1482 in a form that meets the requirements of the law, and 3, the landlord has entered into a contract for the sale of the property with a buyer who intends to occupy the property. So what happens when a tenant claiming COVID-19 related financial hardship fails to provide the required declaration substantiating the tenant's claim of financial hardship? Well, if a resident fails to comply with a 15-day notice, such as failing to pay 25% of each month's rent due during September 1st, 2020 to January 31st, 2021, and fails to provide a COVID-19 financial hardship declaration, and fails to vacate by the expiration of the 15-day notice period, then the landlord can file an unlawful detainer action against the tenant with the court to request that the court awards possession of the property back to the landlord. California courts will begin hearing unlawful detainer actions against tenants who have failed to comply with a 15-day notice period beginning October 5th, 2020. Keep in mind that you cannot serve a 15-day notice to pay or quit for rental payments that were due during the protected period. This information only pertains to notices for rent due during the transition time period, which is September 1st, 2020 to January 31st, 2021. And you cannot file a 15-day notice for missed rental payments that came due during the transition time period until February 1st, 2021 at the earliest. Now, just because a tenant fails to return a COVID-19 financial distress declaration to the landlord within the 15-day notice period doesn't mean the tenant is out of luck. If the tenant fails to return the COVID-19 related financial distress declaration within the 15-day period, the tenant can still file the declaration with the court within the response window for the unlawful detainer proceeding, and the court will schedule a special hearing for which the resident will have an opportunity to explain to the judge why the resident failed to return the financial hardship declaration within the 15-day notice period. The judge will then listen to the resident's explanation before deciding whether the resident's inaction was due to mistake, inadvertence, surprise, or excusable neglect, in order for the judge to make a determination as to whether the tenant has shown a legitimate reason for failing to do what was required under the law. If the judge determines that the tenant's failure to return the financial hardship declaration was due to mistake, inadvertence, surprise, or excusable neglect, then the court may do one of the following. And if it's during the protected period, so if the case was based in any way on a 15-day notice for rental payments due during March 1st, 2020 and August 31st, 2020, again, the protected period, then the court can dismiss any cause of action based on that notice whatsoever. But during the transition time period, if the case was based in any way on a 15-day notice for rental payments due between September 1st, 2020 and January 31st, 2021, the court will dismiss any cause of action filed before February 1st, 2021. Now, beginning February 1st, 2021, if the case is based in any way on a 15-day notice for payments due between September 1st, 2020 and January 31st, 2021, the court will dismiss any cause of action based on the notice if the resident makes the 25% payment for expenses due between September 1st, 2020 and January 31st, 2021. But if the tenant still hasn't paid, then the court will give the tenant an additional 5 days to tender payment. And if the 5th day falls on a non-court day, like a weekend holiday, the court will extend repayment to the next business day. So, in conclusion, as long as the tenant provides a declaration of COVID-19 related financial hardship within 15 days of receiving the notice from the landlord, and documentation if the tenant is a high income earner, and pays 25% of the monthly rent if the rent came due during the transition time period, then the tenant will be protected from eviction for non-payment. So, required notices. For tenants who have missed one or more payments during the protected time period, March 1st to August 31st, 2020, landlords had to have provided these tenants with an informational notice about their rights under AB-3088. And that's this one. It's two-sided. There will be a different notice for the protected period versus the transition time period due to the different statutory language required in each. If your property is subject to the CARES Act, you must provide a notice that complies with both state and federal law. If you had served any notices for payment of charges that arose between March 1st, 2020 and January 31st, 2021, those notices are likely invalid and you should reserve new notices. When serving a notice for the tenant to pay or quit for rent arising during either the protected or transition time periods, the notice must provide the tenant with a statement of the rights under AB-3088, and that's what this one is. This notice should also include a blank COVID-19 financial distress declaration for the tenant to complete and return. When serving a notice for the tenant to pay or quit for rent arising during either the protected or transition time periods, the notice must provide the tenant with a statement of their rights under AB-3088. So, we talked about this. It's very clear, right? You have to give them that notice first, and then they have 15 court days to reply with their declaration. And if they're submitting a declaration to the court, they should also include the cover sheet So because there are different rules for different time periods, a landlord cannot use the same 15-day notice for rent that accrued during the protected time period as he used for rent that accrued during the transition time period. You have to use the specific 15-day notice for each time period. So, you have to give that COVID notice. You also have to give the 15-day notice that pertains to the specific time period for which the rent is due. And if the notice was due for something other than rent, such as a notice to cure or quit, you'll need to serve a separate notice for that, even if it was during the same time period. For any tenants who have missed one or more payments that came due during the protected period or transition time period, or both, landlords must submit a notice. And if you have any tenants who have missed at least part of one rental payment that was due between March 1st, 2020 and August 31st, 2020, you had to have provided a notice to them no later than September 30th, letting those tenants know that if they experience COVID-19 related financial hardship, they cannot be evicted if they missed rental payments between the protected period, but they can be evicted if they missed payments between September 1st, 2020 and January 31st, 2021 if they fail to make 25% of the monthly rent due by January 31st, 2021 and fail to submit a declaration and documentation if necessary. So the landlord cannot serve the tenant with a 15-day notice to pay or quit or a 15-day notice to perform covenants or quit until the landlord has provided the mandatory informational notice to the tenant. In other words, the landlord should serve this informational notice prior to any 15-day notice the landlord serves after September 30th, 2020, if not already served to the resident. And you can download forms from landlordtenant.dre.ca.gov. I'm going to talk about the extension of time for notices, because under normal California law, a notice to pay or quit must be filed no later than 1 year from the date the rent became due. However, due to many local eviction moratoria prohibiting such notices in 2020, landlords will be entitled to add the period of time for which they were unable to serve a notice to pay or quit that became due during March 1st, 2020 and January 31st, 2021, so that time lost will not count towards this 1 year period. In essence, the time lost while landlords were unable to serve the notices due to eviction moratoria can be added to this 1 year cutoff. How to serve the notices. The landlord has the following options for how to serve the mandatory notice to the tenant: regular mail, personal service, substituted service, post and mail. Collecting rent and other charges. For unpaid rent and other rental charges arising between March 1st, 2020 and January 31st, 2021, this rent can be collected through small claims court. The normal small claims jurisdictional amount of $10,000 will not apply for these cases. So all unpaid rent arising during the protected time period shall be converted into consumer debt. Landlords can begin pursuing collection of this consumer debt in small claims court beginning March 1st, 2021. The earliest a landlord can bring a small claims case to collect unpaid rent from a tenant will be March 1st, 2021. Under AB-3088, the previous state rule that had prohibited small claims suits seeking more than $10,000 in monetary damages by a natural person, or more than 2 small claims cases seeking more than $2,500 in a calendar year, has been temporarily relaxed until February 1st, 2025. Again, these small claims changes in which small claims jurisdictional limits will be relaxed are set to begin March 1st, 2021 for landlords seeking unpaid payments that came due between March 1st, 2020 and January 31st, 2021. And keep in mind that although you will not be permitted to have counsel represent you in small claims, you probably will not need counsel due to the simplified and expedited nature of the proceeding. During future screenings, landlords will not be able to see if a prospective tenant has unpaid rent owed to previous landlords. Right, so this is just to protect tenants from basically not being able to find any housing until they've paid off this impossible debt burden that haunts them because they were out of work. They don't have the ability to pay it back, but they obviously need somewhere to live. So what they owe to previous landlords arising during this pandemic will not show up in future financial screenings. Now I'm going to talk about increased penalties, and this is mainly for landlords. So it was already illegal for a landlord to lock out a tenant without a court's judgment in most cases, And under AB 3088, a landlord who illegally locks out a tenant who properly provided the landlord with a declaration for COVID-19 financial distress may become liable for additional penalties of between $1,000 and $2,500. Fortunately, these increased penalties are set to sunset February 1st, 2021. In addition to the penalties for illegal lockouts, landlords are also subject to increased fines of up to $2,500 for landlords who attempt to evict tenants without a court's judgment in the landlord's favor. So here are some examples of what could constitute discrimination, harassment. You can't harass your tenant if they're behind in rent, even though it's frustrating for a landlord to have to pay for the expenses and utilities for someone who's not paying anything in rent. Keep in mind that it's most likely that these tenants cannot work. They would work if they could. They probably had a job when they first came in, but due to no fault of their own, because of COVID, they're not able to bring in enough money to cover their expenses. It's not that they don't owe you the money, they just can't pay it right now. Local ordinances and moratoria. So AB 3088 has attempted to address the myriad, sometimes conflicting, local ordinances currently in place throughout California. Under AB 3088, local ordinances that are set to expire before January 31st, 2021 can remain in place. However, any local ordinances that remain cannot be extended or renewed until February 1st, 2021 at the earliest. Next, any local COVID-19 eviction ordinances that require a tenant's repayment period to begin prior to March 1st, 2021 cannot be extended. For ordinances originally requiring repayment periods to begin after March 1st, 2021, these are now void. Therefore, all repayment periods must begin no later than March 1st, 2021. And because AB 3088 bans repayment extensions beyond March 31st, 2022, this means all repayment periods cannot be extended to tenants beyond March 31st, 2022. And any local ordinance that provides for a repayment period to begin prior to March 1st, 2021 cannot be extended. AB 3088 only permits landlords to require documentation from tenants claiming financial hardship if the tenant qualifies as a high-income earner. However, such local California ordinances may go further and permit a landlord to require such documentation. And that's up to the local ordinance. I don't want to speculate on what they might require and what tenants might fall under that. You'll have to look that up for your local jurisdiction. So, residential payback periods must be between March 1st, 2021 and March 31st, 2022. For rental payments that came due between March 1st, 2020 and January 31st, 2021, no local eviction moratoria shall permit their repayment period to extend beyond March 31st, 2022. No mandatory just cause provisions for rent due between March 1st, 2020 and January 31st, 2021. In other words, local governments can still pass ordinances that require just cause for eviction, provided they do not apply for rental payments due between March 1st, 2020 and January 31st, 2021. AB 3088 provides another facet in the landlord's favor. No longer will landlords notices be expected to comply with the local eviction moratorium or just cause ordinances. Instead, 15-day notices demanding rental-related charges need only comply with the state standard, not the local standard any longer. Finally, for commercial tenants, while the CTRA doesn't apply to commercial tenants, many local eviction moratorium ordinances still do. And because Governor Newsom signed Executive Order N-8020 on September 23rd, 2020, local jurisdictions have the option to extend protections for commercial tenants through March 2021. What is the CARES Act? The Coronavirus Aid, Relief, and Economic Security Act, known as CARES, instituted a 120-day eviction moratorium on covered properties, such as properties with federally backed mortgages and those receiving federal subsidies. While the CARES Act offers limited mortgage protections to homeowners until December 31st, 2020, the CARES Act eviction moratorium expired on January 25th, 2020. However, it required landlords of covered properties to provide a 30-day notice to vacate when terminating a tenancy based on non-payment of rent after the July 25th, 2020 expiration of the CARES Act 120-day moratorium. So the 30-day notice is still in effect and must be combined with AB 3088's requirement to provide a 15-day notice demanding missed rental payments. So under the CARES Act and the CTRA, a tenant who has missed rental payments should be provided the CTRA 15-day notice to pay, or for rent due between September 1st, 2020 and January 31st, 2021, cure by providing a COVID-19 financial hardship declaration and financial documentation of high income, and the 30-day notice to quit under the CARES Act. If the resident is unable to provide the full amount of the declaration and the declaration within the 15-day period to cure, then the 30-day notice to quit of the CARES Act will apply. But again, this is only for properties subject to the CARES Act. So for additional resources, I recommend you go to lawhelpca.org, as well as landlordtenant.dre.ca.gov. SDVLP is a San Diego Volunteer Lawyer Program. That's an organization that I volunteer with as an attorney, and they are fantastic for tenants and landlords. They have attorneys and volunteers, staff and volunteers on site, and they have locations at the courthouse in Vista and San Diego. So that is one organization. If you're in San Diego, that can be very helpful. All right, so to wrap it up, I hope the time that I put into assembling, filming, and editing this presentation has been helpful to you. The purpose of today's presentation was to give you an overview of AB-3088, known as the California COVID-19 Tenant Relief Act. And you may have specific questions about this new law, so I would first check the resources on the previous slide to see if you can find the answer yourself. If you cannot, you would be best served by scheduling time with a California licensed real property attorney. And if you cannot afford an attorney and you're in San Diego, again, the San Diego Volunteer Lawyer Program is staffed with attorneys and assistants who may be able to assist you. I have their information on the previous slide. This has been a challenging time for all of us, and I hope this presentation will make your life at least a little less challenging. I'm Nick Cohenmeyer, and I thank you for sharing your time with me today.